Howdy, my name is Carl Dore. Welcome to the Trends and Traps for 2019 in the oil and gas services industry related to how to analyze and review and see exposure in the risk analysis world. That's what we do as attorneys. We're constantly evaluating and working with risk assessments between the credit management world and the general counsel's departments. How do those fit? How do they react? How do they handle their contracts, their reviews, their exposure? It's more than just what is the operational issues on a frac job. I'm stuck on the well and I can't get off safely and the guy's out of money. It's bigger and stranger today than that. But I think you're going to find it interesting. We have segments of virtually all the topics we could come up with that would fit your world and your interest today. Everything from how to use a petroleum engineer to analyze the complexities of the customer operator, to what do you do after a bankruptcy and they're trying to claw back and take your money back from you. I hope you enjoy it. Get ready. Thanks. The next thing we wanted to do, our last session is going to be me with Ed Rothberg. Ed and I first met in the biggest bankruptcy that we were ever faced with in my office. There was $80 million in vendor debt, in trade creditor debt. My little office had $28 million of it. We were filing liens like crazy. I didn't know what to do. But fortunately, we had a common client who was in that, and we teamed up. And at one point, we're losing badly, by the way. We're losing badly in the hearings, at least in my mind we were. And so we're going into the courtroom in San Antonio, Judge King's office, courtroom.
Yes. Yes, can you hear me?
Yes.
Okay, great.
So we're going into this hall, there's lawyers sitting around the tables, along the edges of the walls, and we turn the corner, and I hear somebody say, well, here's the Ed and Carl show. And I stopped and said, Ed, what does that mean? He said, oh, we're winning. We're winning. I don't know how many liens we filed, must have been a couple hundred. The recovery in that case was 100 cents on the, well, no, it was actually more than 100 cents on the dollar. Right. Because we recovered attorney fees and interest.
12% interest and all of our attorney fees paid.
That's right. It doesn't work that way. All the time. It just so happened that the acreage in the estate was all overlaid the Eagle Ford area. But at that point, there was only 7 wells drilled in the Eagle Ford. Nobody knew it would be what it was now. And fortunately, somebody came and bought it out and took it over. So Ed has been, I've known you from Weiser Kaplan to now Hoover Slovacek to now semi-retired.
Part-time.
Part-time retired. They won't let him retire.
Right.
And some of you may also not know that Ed introduced me to Lisa Rothberg-Aquino, who is in our office and spoke earlier. Okay, so today
there's a little A&M connection there.
There's an A&M connection. Of course there is. So what we thought we would do is run through the last go-round of oil and gas bankruptcies pretty much on a single slide basis. I have a couple of workouts on here, and we're going to tell you what we saw of importance that is worthwhile, that you should take into account now. So they're going to be pretty quick, and then we're going to end up with, well, what did we learn? And what worked, and what didn't, and what should we pay attention to go forward now. So if I click this button, am I going
to be... Just tell them next slide.
Next slide, forget it. Okay, WBH Energy was the very first case filed in 2015, right after, most of y'all remember, November, Thanksgiving Day, 2014, OPEC opened the spigots, oil price collapsed. What happens next? Most of the time, an oil company can last 4 to 6 months before they're in really, really financial shape, unless you drill lousy wells. WBH Energy drilled Barnett wells in Montague County, stupidest place ever. But what we did is we all filed liens. And there was a ton of liens filed. ultimately, there was a formation of an ad hoc committee. Describe the benefits of that part.
Yeah,
You've been in that a lot.
So John, when he was up, talked about the official unsecured creditors committee. And that's appointed by the U.S. trustee, and they get to hire professionals, and the debtor has to pay for it. But so this is a different animal. This is an ad hoc committee, which is just a group of creditors that have common interests, like liens, for instance. They can get together and hire one law firm or two law firms, share the cost, and appear in court on behalf of all of the members of that committee. There's no fiduciary duty to anybody else other than the people on the ad hoc committee. And what that helps you do is you can negotiate a deal for yourself. There might be some other people out there similar to your situation, but if you negotiate a deal for yourself, it doesn't have to apply to them. And so it's a great way to aggregate claims so that, if you show up in court and you have a $100,000 claim, the court might not give you as much attention as if you're on an ad hoc committee and you have $50 million worth of claims. And the debtor might not give you as much attention if you're a $100,000 claim as if you have $50 million of claims in a group and you got Carl Dore and Rothberg harassing you for the entire bankruptcy. So it's actually recognized by the statute that this can be done.
Right. It also allows you to share expenses. You can, an ad hoc committee can hire committee professionals on your behalf, the Conway McKenzie's of the world, or whoever you might decide to do. You can hire common lawyers. Many times we see ad hoc committees where there are multiple claimants, but they have their own counsel. And so you're teaming up on an approach. In this particular case, there was zero recovery from the debtor. Nothing. There was no money because there was no value in any of the wells, and the senior lender was primed or had primed all the minerals. But for those people who filed liens and named the other working interest owners, the other interest owners in the property, those claimants who did the time to do the property research was able to use an ad hoc group and sue those partners and recover. They recover 50 cents on the dollar.
Oh, and one thing just about the ad hoc committee I'll mention is that the way the expenses are shared typically is on a pro rata basis. So like if you have a small claim in a case and somebody else has a large claim, you would share the expenses only on your pro rata portion of the entire group of claims. So if you're a small creditor and you happen to know about an ad hoc committee forming, you want to get in there because you get the power of being with a much larger group, but you're not paying. You're only paying based on your share of the claims.
In that same example, Irongate had an interest in the American Eagle Energy case. They had a 2% share of the effort of the costs incurred. So they were able to really multiply because you can't even afford to have a seat at the table with that. But you can in an ad hoc committee group. On this one, there was a UCC formed. It looked really quickly that it wasn't going to have much recovery. Ultimately, it did not. It was less than 2 cents on the dollar, 1 and 1.5 cents. But there was those that filed liens were able to negotiate a different kind of a recovery, and that recovery in the bankruptcy turned out to be 36.6 cents on the dollar. It ended up to be a huge fight, but because there was some strength in numbers, oh, this has a little light on it, doesn't it? Yeah, because we formed this, we were able to fight settlement efforts that Andrews Kurth was trying to do for the big lenders in the case. We said, no, we can't allow that to happen. It was going to kill our recovery. And settlements that's what makes bankruptcy, settlements. Ed tells me one day, bankruptcy is the greatest invention for negotiation ever made.
Correct.
It's just so expensive.
And let me mention one thing on this slide that's really interesting and complicated. It's the second bullet point, the one that talks, require any sale process to include allocated values in individual properties. So obviously, if you have a lien on the dry hole, your lien is worthless. If you have a lien on the productive well, your lien has value. And typically, when these asset sales are done, the buyer and the seller don't allocate. They're just doing one big price. And then the money comes in to the estate, the liens attached to the proceeds, so let's assume there's enough to take care of the bank and now there's money left over to pay the mineral lien claimants. How do you determine what value you get? Because it's going to depend on what the value of the lease is. And so a lot of times what happens is that right is preserved for a later date. If there's a dispute, and hopefully you negotiate it, but you got to be super careful. Say you have a lien on a valuable property, and you're competing with other people. They're going to say, wait a second, that property is not so valuable. We're going to allocate less value to that property so that when the money comes out, because how do you know how much money was paid for each property? You don't, because the asset purchase agreement is just going to have one purchase price, and it's going to say, we'll allocate for tax purposes later. That's what they all say. So you got to be really careful about making sure that you preserve your ability to contest the valuation on a lease by lease or even a well by well basis.
That's going on today in the Weatherly oil and gas case. That's just pulling it up right now. So, okay. So the next portion of this, in this same case, once we knew we got a settlement from the debtor, which we did, and it was a good one, 36 cents, well, it wasn't great, but it was good in a bankruptcy, right? Don't give up the fight. So we continued to pursue in a different lawsuit. We went to state court in North Dakota to sue against the owners of the properties. And in that, we were able to make a new claim. So we were going after another $2 million. We reached a settlement with them because there was multiple motions, and the judge kept saying no, denied. They wanted to see what we had. So don't give up the fight. Form an ad hoc committee. On this one, Luca Oil, you were debtor's counsel.
Right. This is again, and I used to be in another life a creditor lawyer. I used to represent all the S&Ls and Texas banks that all went out of business. So I lost all my clients. So I had to go do debtor work. So I have a good feel on both perspectives. And Luca Oil really was not that significant a case for this crowd, other than to say that in this entity, all the money that was raised to drill was raised from overseas Chinese investors trying to get EB-5 visas to the U.S. So there were no liens. So, and I know one of the programs earlier today, the credit manager said, "Hey, I look at whether liens are filed, and all the vendors got paid. Because there were no bank liens sitting out on the property. So it is a good thing to do if you have the resources really to check and see if there are liens in terms of figuring out your credit limits and what you want to do and what your risk is. But I mean, and basically what happened at the end of the day was the assets sold. We have the SEC filed litigation against the principal for trying to sell these investment interests to these Chinese people who wanted to come to the U.S. and it's a big mess, and they're never going to get their money back. But all the vendors and the industry types all got paid in full.
I think the principals can't go back to China either.
No, they left already. they left in violation of the court order, and they ain't coming back. I can tell you that.
All right, we switched. I'm trying to do. When I did this and pulled these together, I put them in chronological order. So this was what kind of would happen in the beginning of 2015 as it went on. Samson Energy. This was a pre-packed plan. Everybody's feeling good. Samson at that time had some of the best oil fields in the United States, mature fields. Everybody, I bet in this room, worked for them because they always had workovers. They always had coil tubing jobs. They always had holes in the tubing, you name it. And so it was a great customer. And everybody felt they were going to get paid. But we had to really look at it differently because everybody had preference exposure. So we came up with this novel idea, and I have to warn you, sometimes you have to be ready to do that. And you have to know you're probably going to lose this next hearing, because the point is to win the war, not necessarily because you don't know when that's going to be. So we created something called a notice of receipt of transfers precluding the imposition of mineral rights. Basically, we got paid. So if you want to get your money back, we claim that we can still file liens. And we filed this notice while we were still within lien rights. I know, you're like, is this going to work? We don't know. But we filed it pretty quickly after the case was done. We vetted it with a couple other bankruptcy lawyers that we knew. And they're going, yeah, that's worth a shot. Well, no preference claims for almost 2 years. What's our first argument? Judge, they knew about our notice. They failed to object. They waived their rights. Well, the judge didn't like that, but it was a good try. We also had some other ones. One of the tries was like, but now we want to file our lien in Montana. What did we find out? Montana's law specifically said you couldn't do that. But we kept going, and as it turns out, the law firm who, I don't know if this guy drives the Ferrari, but who took the preference claims, wrote an article to the American Bankruptcy Institute. Did you see this strange notice of receipt? That's the craziest thing I ever heard of. And he's the lawyer. His firm's the lawyer taking all those preference claims. So we then argued, he was not only aware of the filing, he wrote an article about it, proving its validity. Well, we're still fighting the preference claims in that case.
So and the last bullet point, and Carl raised this earlier, is let's say you have a customer who you pretty much know is going to file for bankruptcy, and you think it's going to be pretty quick, and they want to pay you because they want to pay you in advance so that you can continue providing them service. So, well, you know that you can't, after you've been paid, you can't file a lien after you've been paid. I mean, you're not owed anything, right? You have to have a debt to have a lien. So you say, okay, customer, look, here's what we're going to do. We're going to go file a lien, okay? Then you pay us, and then we'll release the lien. Okay, now, I don't know if anybody's ever tried this before, but a payment on a lien debt is, by definition, not a preference. So, if you do that, you might have created a defense to a preference case.
This is reverse manipulation.
Well, just like somebody said here, the debtors are gaming you, okay, and well, you can game them back. Why not? You know, and they might balk at it and say, well, no, we don't want you to do that. And if they say that, fine, you file your liens and you have your lien rights, right? So.
Let me go a step further. More and more counties are allowing us to e-file liens. And so you don't have to go through the whole process. You can e-file a lien in seconds. So if you know the check is on its, or you want to pick it up, e-file the lien, go pick up the check.
And then release it.
I don't know, I just made that up.
But then you got to release it. But then you got to release it.
And then you got to release it. But you release it, you can release it by e-file as well.
Yeah.
Okay, Allied Operating, it was a bad case. I threw it up here for just another reason. And the reason is sometimes make a quick evaluation. We went, this was the deal. The operator had no interest, no title. It was just a shell entity. All of the companies that had the wells were separate limited partnerships. And there was 40 or 50 limited partnerships. And they were all filled with investors, most of which didn't get any money because they were not making money on oil and gas. They were making money on OPM, other people's.
Sounds like a Ponzi scheme.
Yeah, basically. So Jason Searcy was the trustee on this one. And I called him before the 341. I said, I'd like to ask a few extra questions than normal. He said, well, how much time do you want? About an hour and a half. You got it. So went up to Tyler and went through this thing, and all of a sudden Jason takes over because he realized we had exposed some fraud. And we went through it and we found all this problem. We talked about maybe substantive consolidation when you bring in all those limited partnerships, do it all. But at the end of the day, we realized it was going to be uneconomic. So we spent the money on the 341 and decided, stop, kill the case. We're not going to get recovery. Yeah, we can prove a fraud. So economics is still important every step of the way. It's the only reason I put that in there. Energy and Exploration Partners. Is Judge Nelm still on the video?
No, he retired.
Okay, I thought he did. This was in Fort Worth. The judge that when you hear what we've got to say about this, you're going to hate him too.
He's a great debtor judge.
Yeah, he is. Great debtors judge. And that's exactly what we did here. This is one that an involuntary bankruptcy was used to set venue. All the creditors were told, we're going to be filing next week in Delaware. So the creditors got together, 5 of them filed an involuntary in Fort Worth to fix venue. That way we didn't have to go to Delaware and all that stuff.
Hey Carl, who were the petitioning creditors in that case, if you know?
I don't remember.
I'm just curious.
Baker Hughes was one.
I figured this out.
We were trying to be on that one, but they got their 5, and if they would another day, I think they would have probably had 8. So it was there was a lot of people interested in this. But here is the problem with this. There became a fight where all the properties were in East Texas. They were kind of lousy wells, but they were wells. Liens were filed, and the debtors' attorneys had changed the master service agreements to said, normally we give a 10-day notice of intent to file a lien. You are required to give 15 days. Normally you are required, this one said that there was no lien waivers, you can't file liens. And the judge declared, hey, you're big companies. And if you want to, waive your rights, fine. And at the time you signed that, you had no outstanding debt. Therefore, you must have been planning on this might occur. So, and he said this in open hearing, there was a bunch of lien attorneys there, a bunch of trade credit. Zach was for our firm there, and they all got together and said, Judge, may we put something in writing? May we give some briefs? And everybody came home and settled because they didn't want that to be law. Well, it didn't really matter because there's other smart debtors lawyers who got the transcript and has used the judge's statements against us. So beware of this case is what it means to all of us. And this was the one that Lisa talked about that we have on appeal here at Houston 14th Court. Y'all have any questions on that one? I hope that was kind of a little esoteric there, wasn't it? Whoops. Swift. Swift was a cool case. Who expected Swift Energy to file bankruptcy this last time? I mean, that company's been around for 40 years. So on this one, it was a quick evaluation, and the determination was that Swift had a 5-well site. 5 wells had been drilled, and they needed to complete them all, frack them all and complete them. And they needed that to be done in order to make enough money to get through their bankruptcy. Who did they need? Well, they didn't want to call anybody critical vendors. But they were willing to work through some trade agreements. So, the attorney for Swift is Rachel Reese, now on her own. Had breakfast with her a couple weeks ago. And so, called her up. I said, all right, I'll represent, I had 7 clients on this one. I said, and we have this one, this one, this, and this, and you need us, and we need you. And can we work this trade agreement? So we did. It took a week and a half, not very long, but we were able to put in what we needed on behalf of the service companies. And that became the trade agreement for all of the other service companies involved in Samson as they went through. It enabled them to emerge from bankruptcy in 5 months. It was a very quick one. And we gave a little. We said, okay, sure, we will take 90 to 95 cents on the dollar on our current invoices. In return, we'll give you continued terms and do the post-petition work. I thought that was a good deal. I know for a fact those creditors who did not get involved with and team up with others, their payment terms were 60 to 75%. So there's a little bit of advantage when you can team up and it works.
And the trade agreements can be kind of tricky.
Yes.
And I've had clients call and they said, okay, well, we're XYZ service company and Ultra Petroleum filed for bankruptcy and they want us to extend them credit post-bankruptcy. Well, why on earth would we do that? Well, actually, a post-bankruptcy debt is required to be paid 100 cents on the dollar. So unless the entire thing craters, which rarely happens, it's going to get paid. But the trade, particularly if there's a dip financing, a bank that's financing the company going forward, like in this instance, instead of having a bank come in and do the financing, they basically had the service companies do the financing. And the swap was, hey, we'll pay your pre-petition debt, almost in full, I guess. You probably can also ask for a waiver of preference claims.
We did.
We didn't
get it.
You didn't get it, okay, so, and I wasn't involved.
But they ended up, it ended up not, there was no.
They didn't pursue any preference claims, so, but they can sneak a lot of stuff in a lengthy, single-spaced, 8-point type agreement that it would be beneficial to have a bankruptcy lawyer look at to make sure that you're not waiving anything, you're not giving up rights, and the terms and conditions that you're extending the credit on are, you know, it has to be approved by the court so that you have a court order that you can enforce. If for some reason they breach it, you can go down to the court and the court will enforce it. So.
This trade agreement that we negotiated is still being used in multiple cases. Kirkland and Ellis, oh, I love to hate those guys, but they are very smart lawyers, and they're using this one in Weatherly Oil and Gas. We've seen it in some other ones. How much time do we have? We're good?
15 minutes.
Oh, good. Sequel Pipeline.
Okay, Seco Pipeline, that was a case of mine. That was an out-of-court workout. Seco Pipeline was, very quickly, was a company that had a compressor business and also did pipeline work out in the Marcellus. The pipeline work in the Marcellus was a disaster, absolute disaster. And they went into breach of their loan commitments. And this was a case where Conway McKenzie, John's firm, had people who were advising the lender. And the lender did not want us to file for bankruptcy. The lender wanted us to stay out of bankruptcy and try to do this out of court. And with respect to everybody in this room, it wouldn't be something you would initiate, but it might be something you hear from. So when we had the case, we're negotiating with the bank and we're getting forbearance agreements and whatnot. But what do we do with the vendors? Okay, so on the pipeline side, as you probably know, if you're providing services to pipeline, you can file a lien, just like a mineral lien. And so we had probably 100 creditors with about $5 million worth of claims against pipelines. And they were going to file their liens. And just like it was talked about earlier, so you have a bank that has a lien on the receivable. And the owner who you're building the pipeline for, he doesn't want to pay you because he says, hey, you haven't paid your subs. The subs are calling us saying, hey, Seco's not paying you. And so they're not paying us. So the question is, how can you fix it so that Seco Pipeline could finish out the pipeline project, get paid the money, make sure there's no liens releases, there's no liens out there because the owner's not going to pay you if he thinks he's going to have a lien. And so what we did was we went to we created effectively an informal committee. We sent out letters to probably the top 30 vendors to have a meeting. And we brought with them financial information, balance sheets, financial statements, cash flow statements, the loan documents, the whole thing. And we said to them, look, we think we can work out a deal if we can get the bank, to release its lien on the receivables. We'll finish out the project. We'll get the customer to make the payment into an escrow account. And we'll get you paid 35 cents on the dollar, and you sign a release to the owner. And they all kind of looked at us, and it was 35 cents. I says, yeah, what's the alternative? I said, what do you think the alternative is? Zero. Because if those owners aren't going to make any payments, good luck ever collecting the money. So the vast majority of the people that were there said, this is a great idea. We'll do it. And then we had to go to the owners and convince the owners who we were building the pipelines for to do it. And that was harder than getting the creditors to agree to it. But ultimately, we got them to agree. And the whole thing worked out. The subcontractors put their leases into escrow. The owners put the money into escrow. The bank released. Seco got none of that money. All of that money went to the vendor. Now, we had several vendors who said, no, we're not doing that. Okay, we're just going to sue you. So I said, okay, fine, sue us. Well, we're going to get a judgment against you. I said, yeah, maybe in 2 years. What do you mean in 2 years? What's wrong with it? Well, we'll dispute your invoices. Well, our invoices are undisputable. Oh, really? You provided rental equipment. Oh, it didn't work. Oh, you put it in the wrong place. Oh, we didn't use it as much time as you scheduled. I said, I could create 100 defenses to your invoices. You don't want to get the 35 cents? Fine. So we had 5 of them who filed suit out in Pennsylvania, and we defended them. And then once they started to hear that the other vendors were getting 35 cents, they called me up and they said, oh, can I get that 35 cents? Because they'd already spent 50 grand with their lawyers to screw around with it. And I said, no, sorry, payment now is 25 cents. I said, why? I said, because now you caused us to incur attorney fees fighting you, whereas if you just would have stood down and worked with us, we all would have saved money, you could have gotten more money. So the bottom line of the story is if you get approached by one of your customers to do something like this, you know, it's worth considering to see if that's something that will get you a greater return quicker than a bankruptcy. And it was important that the bank was supporting us. And the bank was being advised by Conway, so Conway was supporting us. And you know, and it all worked out. We actually won Turnaround of the Year award for the Turnaround Management Association's Chicago chapter. The turnaround people were from Chicago, so it was a great story. If it happens to you, give it a thought as to whether you want to do that as opposed to just sending your lawyers out to
So
sue.
the key was that you gave them financials. You gave them
Right, we
so
disclosed everything. Everything was just like a bankruptcy where you get the open kimono. Now, any one of those vendors, if they had gotten a judgment, could have forced us into a bankruptcy. Because once they got a judgment, they could, and there was actually one with a small amount, like $50,000.
And what color is your Ferrari?
Black. Actually, it's not a Ferrari, it's an Audi, so it's a little cheaper.
All right, we put Energy 21 up here because it was so big and such an interesting case. This was one where the mineral lien issue became decisive in the case for recovery of the creditors. It started out kind of strange though. There was a 341 meeting, and lots of good stuff can come out of 341s. If you don't go to it, if you don't join an unsecured creditor committee, go to the 341 meetings. You can ask anything you want because you're a creditor, and the principals have to show up. On this one, we asked 4 questions. And basically, at this point, there have been several cases in a row. All we had to do was present information that we had the ability to file a lien, we knew the well, we knew the timing, here's our data. And that was good enough. This one, we asked those questions. If we give you this information, is that enough to demonstrate the ability to file a lien so we don't really have to? At the 341, the principal went ballistic. He just said, anybody who files a lien, we're fighting you, we're attacking you. Nobody's gonna be doing that. The whole rest of the room went crazy because all the other lawyers started jumping in. And my firm had to end up writing a letter of apology for starting this chaos. It was great. So everybody filed their liens. Everybody filed their liens, of course. There was a bunch of critical vendor motions, and that's why we had to do it. One of my clients was a critical vendor. And he said, why'd you make them mad? whatever. And the principal at Energy 21 was an Aggie petroleum engineer, and he knew who I was, and I knew who he was, and he was just mad.
They went to school together.
Well, he was I was older than him. So in any event, that's all we had on that one. M&G Corp Chemtex, this is the one that James Clem was talking about when we were doing the credit advantages issue. And it's one that I wanted to bring up because there is a connection between the construction world with M&M liens and oil and gas world that are mineral liens. And we're seeing it more and more, the pipeline area particularly, more and more. Many times we have a pipeline, well, what do you want to lien? The whole pipeline? That steel in the ground? What about the endpoints where the compressor facilities are? That's where all the value is. So evaluate that, I mean that. On this one, we were able to join an ad hoc committee again. We had a force in numbers, and we were able to work a deal that worked out for everyone.
Something's missing.
Oh, Weatherly, I'm gonna skip Weatherly. It's still going. There was, you have to watch out sometimes in bankruptcy for the last minute stuff. There was a motion filed late on a Sunday night, and the hearing was gonna be on an emergency to replace the master service agreement. Here's the deal. Weatherly Oil and Gas was in bankruptcy. Weatherly Operating was not. That was their wholly owned, all the employees were with that company. It had no reserves, had no leases, had no nothing, right? So what do you do? Well, you watch they want to change the MSA and fix it so all the salaries of those people, well, they were overpaid in accordance with the guidelines under the bankruptcy code. So they're going to reduce their salaries. Look how great and wonderful that is, Mr. Creditor. We're just going to take the remaining difference, and that's going to be a bonus if they continue working through the rest of the case. So we filed an objection. The UCC filed an objection, and even the U.S. trustees said, man, there's something up to this. We're filing an objection too. So then there became all the negotiations, and they got it done. So you want to be careful. Object to what's important. Don't be silly about it, because the judges will pay attention to you. So then we want to go to what was important of all this stuff. This is what was important in the 2010 to 2012 go-round of bankruptcies. And it was a little bit different, but somewhat similar. What we learned is this. Evaluate the preference exposure immediately. We learned that if you file a contingent lien, did anybody remember what those were? You got paid. You file a lien anyway, and you say, this is a contingent lien. In case they want my money back, then I have a lien. That was declared to be a violation of the automatic stay by a judge in Delaware. And so we had a bunch of those. We just quietly released them. Vendor financing became a thing. There were several companies that had drilled wells, not completed, and so the vendors got together and for a premium price, list price plus a premium, they did the work to get the wells online, to get the money into the estate so that they could do creditors. So that became a thing. We used credit bid strategies. You want to talk about that in TXEO for a minute?
Yeah, well, that was the case. If you remember, there was no bank lien.
Okay.
Credit bid really only works if you're the first lien, because if you're the second lien, you take subject to the first lien. So we said, okay, well, we're the first lien holder on this Webb County property, and if you want to sell it, our group is owed, I don't know, $80 million. We'll buy it for $80 million.
Like a bank, with credit bid.
Just like the bank would do if they foreclose. And that threw a firecracker into their whole deal.
It was a bomb.
But I mean, in all fairness, in that case, the whole Eagleford and the price came up, which really helped everybody out at that point in time.
It did.
So we didn't actually have to exercise that remedy.
We did not. All right.
But we threatened it.
So this go around, here's what we learned and what worked this time. Number one, once again, consider service on an unsecured creditor committee. You can get information. Since so many of the cases are being filed in Houston, the Houston trustees understand that just because you file a lien, you're probably going to be unsecured as well. Maybe a part of it is good, but maybe a part of it is not. So why should you be denied the ability to preserve your rights to your unsecured portion? And they'll let you sit on the committee. Form an ad hoc group. Take the money now. Think about allocating it.
Yeah. Let me mention this concept. It's very important for credit managers, and it's very counterintuitive, which is, Hugh Ray said earlier, everything in bankruptcy is counterintuitive. But if you suspect that a company's in trouble and they're going to be paying you money, okay, the normal application of the funds come back and you put them at the oldest invoice first. So now your oldest invoice is 180 days old. You get sued for a preference, and they say, hey, that's out of the ordinary course of business. Question?
What about your remittance advice that comes along with that payment, and they allocate payment to those specific invoices, and you misapply the cash? How's that handled?
You still have to apply it to the invoice that they direct.
Well, not necessarily. Not necessarily. I'll explain that. Let me finish this concept, and I'll answer that question. Okay. So what I have told many credit managers to do is, if you suspect a problem, the money comes in, allocated to the newest invoice that's within terms. And then when they sue you for a preference, you can say to the judge, look, our invoice says payment in 30 days. We receive payment at day 22, that's ordinary course. It's almost a safe harbor. Now they're going to say, oh, you switched it. We ordinarily paid you in 120 days, now you did it in 30. Well, that's a pretty tough argument to make. And I actually won that argument in a $2 million preference case in Houston, where I was defending the preference party. So I know you don't want to do that because you want to clear out your old AR, but isn't it better not to have a good defense? But let me answer your question about the allocation. So there's a common law concept about that. If there are multiple debts and the debtor is not in default, the debtor can designate wherever it wants to put those payments. But if they are in default, i.e. they haven't paid you within terms, then you can allocate the invoice to any invoice that you want. That's a common law concept that's been around since probably England.
It voids out the remittance advice instruction.
Right, if they're in default. If they're in default, you have, as the creditor, it's just like the classic example is much easier to think about it because there's not a remittance advice. Borrower has 3 loans from a bank. Okay, the borrower is in default, and he sends in $1,000 and says, apply it to loan number 3. But the bank wants to apply it to loan number 1. Well, the bank can do that because they're in default. But if they're not in default and the debtor says apply this to loan number 3, even if the bank wants to apply it to loan number 1, they can't. They have to apply it to where it's directed. So it does void the remittance advice.
Am I the only one who didn't know that? This is the first time I've ever heard you can apply to different.
Yeah.
I didn't know that. So
Do you have to inform them how you apply?
It's a good practice. I
It's
mean,
also a good practice to apply the way they said. I'm just.
well, no, not necessarily. Because like if you want to take my advice and apply it to the most recent invoice, then and they've applied it to the oldest invoice. See, that was the thing about the deal where if you're extending new credit and then they're going to pay you on the old invoice, that's screwing yourself. Because once they file for bankruptcy, that you're not going to have any real defense to that preference claim. So you want it to pay you. You want them to pay you on the newest invoices first. So.
And if you do this and you succeed, how many people in your company are going to say, that was a really good idea? None. They won't ever know.
Well, yeah, they'll say, why on earth are you applying to the newest? We want to get rid of the old.
Okay, so the very bottom line, because we're now out of time, the very bottom line that we learned in 2010 and in this latest go-around is the same thing that we know now, because we are in the world of unsecured credit, basically. That's what you do every day. So here's what you do.
So wait, you can just tell them. You know what the last
I know
slide
the
is.
last one. File perfect liens. File perfect liens. That's the bottom line to protect yourself in what we do every day, in bankruptcy times, to move your claim, well, there you go. To move your claim from unsecured pool down here at the bottom. The only people you're ahead of is shareholders, because they're wiped out. And you want to be as far away from those people as you can. You want to be higher up on what we call the waterfall analysis, the waterfall of who gets the money first. And you want to try to move your claim ahead of unsecureds, even if you're just buying back. So with that, we're done for the day. And I hope this was what you were hoping to get out of it. And because what we were trying to do is establish some things that are new, some things, maybe some tools that you could see and to use. And with that, the next thing is happy hour, and I don't know where that is. Oh, and thanks to our partners. And happy hour, Tom, is
Right outside.